you. Good morning. This is Thursday, January 27th, 2022. We are taking up a bill regarding medical monitoring. It's S113. I would establish a cause of action for medical monitoring. We had testimony last week from several witnesses, and today we're going to hear from several more witnesses and then hopefully make a decision about the bill at 10:30 a.m. after we've heard from the witnesses. I believe Matt Chapman is not going to be available this morning. The agency feels that they're comfortable with the bill the way it stands, given the situation. Good morning, Senator Baruth.
Morning.
Given the situation in Bennington with the settlement. So, I want to once again just speak so highly of the Agency of Natural Resources, Peter Welk and his entire crew who were down in Bennington from day one. Government at its best, really, helping people to get water, helping them to get tested, assuring them that they were doing the best they could. And there were several of them, but Richard Spieth, who pretty much moved to Bennington, even bought a car in Bennington, a staff member of the Agency of Natural Resources went way above and beyond to help the people of Bennington through this horrible situation. So just wanted to mention that since Matt won't be here. I'm going to start with Warren Coleman, a lobbyist for MMR LLC. Warren, good morning.
Good morning. Good morning, Senator Sears, Nitka, Baruth, Benning, and White. It's good to see you all. It's been a long time. Can you hear me okay? Is the audio all right?
Yes. Yep.
Okay, good. Super. I've actually never testified before your committee on this subject. I've found myself doing most of my time over in the House committee. So it's good to be with you and to talk about this. Just as background, I worked on this bill, the prior version of this bill, S37, which I've talked to all of you about at one time or another over the last biennium. But as I said, we spent a lot of time in House Judiciary, and what we were trying to do there. And I went back and actually looked at a letter that I sent to the House Judiciary Committee back in April of 2019. And what we said then, and what I think is still true today, is that the goal then and now was to find a path forward for medical monitoring by harmonizing the legislation that you had introduced with judicial decisions where medical monitoring had been recognized in other jurisdictions. And ultimately, S37 made some progress in that direction, but didn't go quite far enough, and ultimately was vetoed, as you know. But something important happened, and that late in December of 2019, Judge Crawford issued an order in the pending litigation down in Bennington that articulated a legal test for medical monitoring that he would use in that case had it gone to trial. And that was the first time that the courts in Vermont had set forth a legal test for everyone to take a look at. And as you heard from your alleged counsel, Mike O'Grady, that was a well-written order, and that the legal test that he articulated was based on other federal court precedent. And that's exactly what I think the parties and all the stakeholders were trying to do during the last biennium, but didn't quite get there. So I think the bill that you have in front of you, S113, does use the appropriate legal standard. It uses Judge Crawford's standard. And we thank you for actually putting this into the bill and including it in 113, because I think it basically settles the primary issues that we were all trying to work through to find a bill that would work for all the stakeholders. The legal test and then the accompanying definitional changes that are made throughout the bill to mirror the language in the legal test should significantly reduce the legal and financial risks that were the basis for the prior vetoes of going back another biennium, S197, and then S37. And those were of the greatest concerns to the business community, was that uncertainty around the ability to obtain insurance, putting a legal standard in place that was significantly different than other jurisdictions. So 113 does take care of that. There's one thing that I would ask you, one additional conforming change that I would ask the committee to make. And you discussed it during your last hearing. Senator Baruth raised it. I believe Senator Benning raised it. I know Mr. Groveman raised it, and so did Mike O'Grady. And that's including the word proximate as part of the causation standard that was articulated in Judge Crawford's test. It's not in 113. It is typically the type of causation standard you use for tort type claims. I've spoken to some of the advocates for the bill, including Mr. Groveman. I think everyone's of the opinion that putting that word in and making sure that it mirrors Judge Crawford's test as closely as possible makes sense and gives everybody a level of comfort. So we'd ask you to make that one conforming change. With that, we're hopeful that this change and using the appropriate legal test, that you can advance the bill, you can provide Vermonters with the relief that everyone has been looking for and hoping to advance. And you can do that without creating an unreasonable risk to Vermont businesses. I think the bill, after a very long time of working on this, strikes the right balance. And, based on my conversations with the folks you'll hear today, who I've worked with over the years, the Lake Chamber, the State Chamber, AIV, some of my individual manufacturing clients, that it strikes the right balance and represents, I think, a compromise that everyone can live with and that the bill can advance with. So I'm happy to take any questions if you want to get into any particular details, but I think really that one conforming change would go a long way to making sure that legal test is directly in line with the federal court test. And that's really what we've been trying to do, quite frankly, for the past 3 or 4 years. So with that, I'll take any questions.
Where specifically does proximate, how would that read? And what section are we talking?
Senator, that is exactly on page, on my copy of your bill. It's on the very top of page 6, and it's the 4th out of 6 elements in the legal test.
Oh, yeah.
So
Yes, as a result of the
yes,
exposure, plaintiffs have suffered an increased risk of contracting a serious disease.
Correct. So
As
the
a-
addition of the word proximate in front of the word result is the conforming change to Judge Crawford's test.
Before result.
I'm sorry.
Yes.
It would read as a proximate result of the exposure.
Correct.
Okay. Thank you.
You're
Are there
welcome.
questions for Warren?
I just I had been thinking of it in my mind as proximate cause, not proximate result. Can you say approximate result?
Well, I'm just going to pull up Judge Crawford's test. Give me 1 second. Judge Crawford's test reads as approximate result of the exposure. I mean, that is another way of saying that I
Okay.
use the word, it's the element of causation. That's really what we're getting at, is what series of events caused the result of this of the exposure.
Yeah, and I suppose if it's approximate cause, then you can flip it and say it's also approximate result. So, all right, thank you.
Frankly, I don't have a problem with following the Crawford language. Personally, it seems to have worked in the settlement with the, but when we get to markup, we can discuss this further. All right. Our next witness, are there any questions for Warren? Warren, thank you very much. Stay warm there.
Thanks.
Chris Kerrigan, Vice President of Business Development for the Vermont Chamber of Commerce.
Thank you
Welcome.
very much. Thank you, and thank you. Chair Sears and committee members, for the record, my name is Chris Kerrigan, and I'm the Vice President of Business Development with the statewide Vermont Chamber of Commerce, which represents 1,200 member companies from Bennington to Newport. I also manage the Vermont Chamber's Manufacturing Division and also the Vermont Chamber's Aerospace and Aviation Association. To begin, and for a brief overview, Vermont is home to 2,100 manufacturers. Vermont's manufacturing industry generates almost $3 billion in total economic output, representing 9.23% of the state's gross domestic product, and employing 34,000 Vermonters with an average annual salary of almost $60,000. Many of our manufacturers operate in compliance with existing state and federal laws and are responsible environmental leaders, providing Vermonters with employment and a high standard of living. Over the past 22 months now, Vermont manufacturers have weathered the pandemic, but now face soaring inflation, energy costs, supply chain disruptions and bottlenecks, and severe worker shortages. Regarding S-113, a bill that proposes a cause of action for the remedy of medical monitoring, the Vermont Chamber supports the recommendations provided in prior testimony on S-37 that have been included in this new bill. These include updated definitions of disease, proven toxic substance, exposure to the substance, release, and tortious conduct. Regarding medical monitoring claims, the updated legal test, including criteria for claimants to have a cause of action and seek a remedy under Section 7202 medical monitoring for exposure to proven toxic substances, and with a few differences, appears to align with the legal test articulated in the ruling by the U.S. District Court Judge Geoffrey Crawford. One difference, however, is that S-113 uses a slightly different legal test for cause than in the Crawford decision. If the updated legal test in S-113 mirrored the Crawford test, it would provide greater certainty for our manufacturers and an otherwise already disrupted supply chain during the pandemic. As such, the Vermont Chamber recommends the committee change as a result of the exposure to as a proximate result of the exposure, echoing what Warren just testified on. Additionally, the Vermont Chamber has concerns regarding the insurance market and encourages the committee to hear from the Vermont Department of Financial Regulation on whether medical monitoring insurance can be written for Vermont companies, especially for the small and medium-sized enterprises, what we call SMEs, and the small and medium-sized manufacturers. If not, three scenarios could disrupt the insurance markets, further impact our supply chains and economy during the pandemic, and subject manufacturers to significant risk and costs under S-113 as currently written. Manufacturers, for example, may not be covered under their existing insurance policies for medical monitoring claims brought under S-113. Manufacturers may not be able to obtain insurance for medical monitoring claims because insurance companies will exclude it from their policies. And then lastly, manufacturers may need to secure special insurance from secondary markets not regulated by Vermont at extremely high costs. An added cost, along with the aforementioned pandemic pressures, will place our manufacturers at a competitive disadvantage. So in closing, the statewide Vermont Chamber of Commerce is really glad to see that our previous recommendations were incorporated. The Vermont Chamber supports alignment with other states and court decisions, particularly federal decisions, for reasonable and balanced standards and criteria. The Vermont Chamber recommends mirroring the updated legal test in S-113 with the Crawford test, and importantly, recommends hearing from the Department of Financial Regulation and getting clarification for the insurance markets and our manufacturers. And with that, I'm happy to answer any questions that you might have.
Any questions for Chris Kerrigan? Yeah, DFR, we can try to hear from them. Once we have a final draft, we can ask them for their opinion. I'm not sure what it would be, but okay. Thank you. Other questions for Chris? Chris, thank you very much for your testimony.
Oh, my pleasure.
Bill Driscoll, with the Vice President of Associated Industries of Vermont. Welcome, Bill.
Thank you, Mr.
Nice to
Chairman.
see you.
You too. Appreciate being before you folks. And again, for the record, again, it is Bill Driscoll with Associated Industries of Vermont, representing primarily the manufacturing sector in Vermont, although we also have other members as well. And as you know, we've been very much involved with this issue and legislation for quite some time. And I do appreciate the fact that it does appear that we've come to a point where the compromise we've been trying to work toward is before us in terms of, at least with regard to the medical monitoring provisions in the bill. I think Warren and others have certainly laid out what our concerns have been and recommendations have been over the years. I think particularly with the additional conforming recommendation on approximate that's been discussed. I think that if there is going to be legislation on this issue, as opposed to continuing to rely on court precedent, this language represents the compromise we were recommending and asking for in the previous session. So I just want to recommend or acknowledge that and appreciate that. One area that we still have some uncertainty about is section 2, which is not really medical monitoring. That's the sort of question of more liability issues. And in that section, I think the issue for us is kind of trying to balance two potential poles. One, a situation where you have potential confusion or time and litigation and downsides of trying to parse out potentially multiple parties of responsibility in these kind of cases on the one end, and on the other potential extreme end, you have a situation where an individual party may be held solely responsible and either A, kind of gloss over or not really acknowledge the potential for multiple parties, but also the question of whether the standards or the tests that parties can be held to is both clear and fair. And that's not to say that the language here is definitely one or the other. We just have some remaining concerns as to whether the language is clear enough and fair enough, and whether maybe additional changes might be warranted. To be just to let you know, we've reached out to A&R. We're in the middle of trying to talk through with them whether there might be additional changes or even frankly getting greater clarification on the language that they've put forward to hopefully have some reassurance on that. At least one clarification that we have recommended is on page 10 of the bill, at the top of the page, where it basically makes clear that if a company provided adequate warning, that's a defense against liability. That does kind of leave open the question, what exactly is adequate warning, and what form would that take? Sort of a concrete recommendation that we would have would be to include language there that clarifies that an OSHA compliant safety data sheet, which is a fairly standard documentation in this area, that would be considered the format for adequate warning. Now, I would say that our initial discussions with A&R about that are positive, but they have not, they certainly have not taken a position on that. So I don't want to misrepresent that. We're in the middle of discussing with that. They're considering that, and we're certainly hopeful that they would be supportive of that. So although I would recommend that to the committee, I just want to be clear that we are talking with A&R, would hope to find consensus with them on any recommended changes to the language in here.
Right. Well, as I said earlier, A&R felt pretty comfortable.
I'm sorry, Mr. Chairman, I don't know if you froze in there.
I think maybe he did.
Yeah.
Actually, if maybe I'll just, Dick, are you there?
Yeah, I'm here. I don't know. My internet's unstable again.
Could I ask Mike O'Grady
Sure.
just about that language on notification, Mike? Adequate warning. What would provide adequate warning? I'm thinking of the Bennington situation. What would constitute adequate warning in that case?
Well, without further clarification, I think it would become a fact-specific question before a court.
Yeah.
And for example, Mr. Driscoll just referenced the material safety data sheets. If the exposure was going to be in that workplace where OSHA does require a material safety data sheet, I think the manufacturer would have a very good defense if they had posted the MSDS and it was available to the person that was exposed.
Well, and I guess that would be my question. So somebody working in the plant
Right.
might have access to those documents, or they might be posted where they should
Right.
have seen them. But people living outside the plant,
Well, then I think you would be looking at things like consumer product safety warnings on the product itself, if the exposure is going to come from the product. Just harking back in time to the 70s, that PCBs had building material, had warnings on them. They may have had a defense at that.
Although again, if so somebody being employed there or somebody buying the frying pan that has Teflon on it, those are two possibilities. But I'm thinking about somebody who would this immunize somebody even though they injured a swath of people who they never bought the product, they wouldn't have seen a product warning?
But I think that's going to be the difficult case. That's the difficult fact scenario with this language. I don't know how an adequate warning could be provided for a population where the exposure is due to a failure of the chemical to incinerate in the production process or deposition of the chemical through emissions. I don't know how the manufacturer would provide an adequate warning of that. That you could argue that their permit, which should have had some reference to the material and the adequate combustion of it or treatment and emission, would have been adequate public notice. But if they fail to comply with the terms of their permit, then that's really not adequate notice.
Okay.
So it's a good question for that fact scenario. For the products, I think you have, and it's any person who manufactured for commercial sale a hazardous material. So it's for that commercial sale of the hazardous material. It's not the deposition or the failure to combust. It's the commercial sale. And you can say commercial sale of a product that contains a hazardous material. And then I think you have the adequate warning with an MSDS OSHA compliant, and then an adequate warning on the product itself. I think you could probably address those two concerns.
Bill?
Okay.
Yeah. So it's my understanding this provision is actually looking not at the product and consumers, but it's looking at the communication between the chemical supplier and the manufacturer using that chemical.
Yeah. I think it could be both. I think it could be both.
If again, I don't want to blame DuPont because I can't remember if it was DuPont or which manufacturer manufactured the Teflon that was using the manufacturing process at ChemFab. But I believe that if DuPont had notified ChemFab, that would have fall under this, but they didn't.
So without speaking to the facts of that situation or not, which not an expert on, but yeah, that is the kind of relationship. It's our understanding that this would be, that this
Yeah,
is addressing.
right.
To be honest, I think if this is going to be applied beyond that, I'm not sure that that's really been discussed or understood before. That actually raises a lot of potential complications and concerns.
I
I
think
can't, I can't speak to right now, obviously, because this surge is coming up right now, but I guess we're gonna have to look into that.
I agree. Although I think my concerns that it raised are opposite to yours, Bill. I mean, I wouldn't want to
I'm
go.
sure our ultimate goals are not, but maybe the way we get there.
Understood. I wouldn't want to go through all of this and then have a situation like Bennington. The company has an out because they printed in very small print somewhere that their chemical was hazardous, but the surrounding people, the residents who were poisoned, would have no way of knowing. That, to me, that's not adequate notice.
Yeah, and again, it's my understanding that we've strayed far afield from what the intent of this language, the kind of circumstances that this language was supposed to be getting at.
I'm going to do an unusual thing, and that is suggest that we've already moved into the markup phase, which allows more discussion. And since we've come to this, were there other things, Bill, that you wanted to discuss in the bill?
No, I just wanted to just observe that obviously, one of our major concerns has been insurance impacts. And as we said, this reflects a compromised medical monitoring test that we were recommending and supporting. So we'll simply, one of the things obviously we're gonna want to do is, barring, newer or strong objections from DFR or anybody else in the insurance sector, we'll certainly want to monitor the practical effects if this bill were to go into effect as it is. And, if we do see impacts on insurance, we're hoping to come back to you and your colleagues in the legislature to try to address those.
So why don't we move to markup? And if you don't mind, we may be ahead of ourselves here, but Bill was our final witness on the list this morning. So I would ask John Groveman if he has any comments on either of the suggested changes or concerns that have been expressed.
Thank you, Senator, and thanks to the committee for your continued work on this. Yes, as you go into markup phase,
You probably should identify yourself
yes,
for the record.
sorry
John.
about that. So John Groveman, I'm the Policy and Water Program Director for the Vermont Natural Resources Council. We have no objection to adding proximate into the part of the test that was discussed. As we talked about last time, I don't think it makes a significant difference, and I think it makes sense to mirror the Crawford test. On the issue that you were just discussing, and I'd be interested to hear what Michael Grady has to say about this. So I'm not saying that the issue that Bill is raising is not, shouldn't hear from A&R on what Bill is asking for and the concerns he's raising. But I just want to point out that the context of this is really limited. This section only applies to the state, right? The state this is not private lawsuits. This is not, a situation where, Vermonters are going to be hurt and they're going to seek, relief with the lawyer through the courts for their own personal injuries. This is the state recovering costs that it incurred due to a release of toxic chemicals on public resources and on public facilities. And the background for this is, we talked about this a little bit last time, is we're seeing, especially with PFAS, because it's so prevalent and it doesn't break down, that it's in all, like across the country, it's in treatment plants, it's in water supply systems, it stays in public waters and needs to be cleaned up. And some states across the country are suing manufacturers of chemicals to basically recoup those incredibly significant costs, right? And I believe in Vermont, the Attorney General has joined a lawsuit with other states trying to recoup some costs along these lines, but they have to use the common law. because we don't have this provision. We don't have a provision that says the state can sue a manufacturer. So Vermont is trying with other states to sue the manufacturers of PFAS to provide some relief for trying to deal with these impacts to these public facilities. And this provision would just create an easier path. We wouldn't have to argue about whether or not Vermont could take that action against the manufacturers. Still have to prove the case. Still, a steep road. Anyway, so I just think that's important context. I want to make sure that the committee understood that.
It's the state only.
It's a state only, right? So, there's the private lawsuits exist today for negligence, for people who are harmed by chemicals, the medical monitoring provision as a remedy that people could seek. And this is a provision that Bill has raised is about the state, it's being able to recoup those costs.
So, but section 2 was not part of the Crawford.
No, it's a totally different
To make
section.
clear,
It's-
to make clear that
It was something that came up as the bill was considered last time, I believe, because of the PFAS. As the committee, I'm sure knows, the ANR has done testing for PFAS in wastewater facilities and water systems over the last several years, has found it in almost every system it's tested, and found it in some systems in really high quantities. And so that's where this idea came from. It came from the state, but VNRC and other groups really support it because we've seen other states around the country, using these type of provisions to help try.
5 is an added provision to current law regarding defenses.
Right. So the section 2 amends 10 VSA 6615, which is when the state can pursue liability against someone for the cleanup of a release of a hazardous material or to remediate the effects of a release of a hazardous material. And so in a release is usually a discrete event. And so the liability there is usually limited to cleaning up the release. But remediation, that is a situation where the hazardous material can be pervasive in the environment. And Bennington's a good example. The hazardous material was pervasive there, and then remediation takes a lot of different forms, such as providing drinking water to those that are affected. And so it is the states seeking the remedy of remediation. It is not for the private damages to a homeowner or business or other. That's what they're seeking to clean up. And currently, liability is authorized against the owner of a facility that released it, the operator of the facility that released it, the person that arranged for the material to be there, or the transporter. So you can see that the manufacturer who provided the material to the owner or operator of the facility is not necessarily covered in those 4 categories. And if that manufacturer had reason to believe that the material was hazardous and failed to provide adequate warning, that's what Section 2 gives the state the opportunity to pursue liability for.
Okay. That's helpful. Any other comments or questions? Well,
Can I comment on the insurance issue just really briefly?
Sure.
So by all means, if the committee wants to hear from DFR, of course, hear from everybody who has something to say about any bill. That's the way it should be, and I think the way it is. But this issue has come up in the other 2 versions of this bill, and I don't understand how DFR and the insurance industries, so the Judge Crawford's decision could have become final, and this could happen at any time. There could be another lawsuit, and like I said last week when I testified, it's just that it's going to delay things. It could be 5 or 10 years before a court sets the authority for victims of pollution to seek the medical monitoring remedy. I don't understand why the insurance companies and the insurance regulators wouldn't want to get out in front of it and just not wait for a court. I don't know what's more uncertain than knowing when a court's going to drop a decision from the sky that is going to affect businesses and the insurance that they need. Why not, as we've now got a bill, and I really want to thank, I appreciate Warren and Bill and the chamber supporting the language. This has been a long journey, but we have a bill now that we agree with this language. There's provisions that address Vermont specific issues like farming and the small facilities. We limit the ability to seek the remedy. Why wouldn't it be better for the insurance perspective to have that certainty rather than waiting for something to happen and then having to react, and then one day people are going to need the insurance, eventually. And not to mention, obviously, that we all, I think, want to help Vermonters who are in these terrible situations, and the timing of when insurance has to be obtained, because there's a new right to basically try to deal with harm caused by pollution. And that shouldn't, in my mind, drive the policy of creating the ability of Vermonters to just seek those sort of damages when they've been harmed. So I don't know. So that's my perspective on that. As I said, we'll see what the committee does with that request, but
we
just wanted to put that
we
on,
did,
on the record.
We did, as we have had so much experience with this issue that we had a witness list that we went through. And we asked people to comment. And as I said earlier, the agency didn't have any comments at this point unless we absolutely needed them. So Matt Chapman dropped off, and we did contact DFR, and they had said they had nothing new to add at this point. So I'm not sure. I mean, we can wait. But when they said they had nothing new to add, I'm not sure what that would get us.
So thank you for the opportunity just to
Thank you.
have that input.
So, committee, Mike, I think if the committee's okay with it, I'm okay with adding the word proximate that Mr. Coleman recommended and that several others have recommended. I don't know if it's any way to clarify that section 2. I wrote down that this establishes liability for hazardous material release, and I think it's clear that it's the state. This section of law, section 2, and we've added a few things. Who knows or should have known the material presented a threat to harm to human health or natural environment, which is the cost of the cleanup. And I think on page 10, I'm pretty comfortable with that language personally, but the committee, where do you want to seek any other changes besides the word proximate?
I'm fine with it as it stands with that change made.
I'd like to be fine with the whole thing. I just would like to ask about the small business or person who has employed 10 persons or less, or 10 persons or more. I'm not sure why that has to be such a low number.
Philip,
If I might, I remember that argument. We talked about it in committee for a long time. In Vermont, if you exempt people at that number, you're exempting a huge number of businesses. I think we actually had at one point considered a higher number, and then we were exempting almost everybody. But Vermont is a really small business state. So I forget the exact percentage, but 10 employees or less, I want to say is something like half the businesses we have. So I personally, I didn't want to exempt 3/4 of business or 4/5 of business from what I regard as very basic protection for average Vermonters who are not in business but are trying to live their lives. I think Joe was the proponent of protecting what he called the mom and pops. And so in order to protect the mom and pops, we got to the number 10.
I think that,
That's my memory of it.
so just with regard to that, it says at any time. You know, it's not like a business that's operating as one business. At some point, it might be over, 25 years that the person has.
No, I think they have to have at some point had 10 employees working at the same time.
Does it
In
say?
other words, I
What?
believe,
Is that clear, Mike O'Grady?
in other words, not historically have they ever employed in total 10 people, but was there ever a time when they had 10 employees working at once?
It does say haven't been employed at any one time. I see Senator Nicka's point where maybe someone is saying that that's historically, but as maybe it could, but it's intended to be where 10 employees have been employed at a certain snapshot in time, certain
I think
period.
It's important to me that we make sure that we're exempting those we want to exempt, since Crawford exempts no one. If you just went with pure Crawford and that became the standard the courts used throughout Vermont anyway, and maybe the Second Circuit, you would end up with no exemptions whatsoever. So the exemptions that are built in here are beyond the Crawford, as I understand it. I stand to be corrected if I'm wrong. So I'm happy to make certain that it's at any one time had more than 10 employees. But, that's the intent. We're exempting the mom and pop. That's, as Senator Baruth said. But are we making clear that in 1952, they hired 2 people, then they grew to 5 people, and those 5 people retired and they hired another 5. Is that 12 or is that 7 employees?
Under this, it would be 12.
Well, that's we need to make clear.
Yeah.
So you could just say where, comma, at any one time, comma, 10 or more full-time employees have been employed.
Yeah.
I mean, it's just moving
Or
that
equivalent.
phrase.
I
at
think you
any
have to
one
use the
time.
term or a full-time equivalent, because then you get into the Walmarts that don't want to hire anybody full-time because they have to give benefits. Well, I probably will get slammed by Walmart, but certain businesses don't give people 40 hours. They try to keep them under that threshold so that they don't have to provide certain benefits. So probably should read full-time equivalent. Senator White. Senator White and Senator Benning.
So this would exclude consultants or subcontractors, right? If somebody has a business and they employ 4 people, but they need to hire a subcontractor company, ServPro, or somebody to come in to do things, those aren't considered their employees. That's right, Michael?
They're not employees, or either contractors or consultants.
Okay, thanks.
Senator Benning.
I just want to float this out there. Michael, I understand what the bill is trying to do. Should there be a nexus between the number of people employed and what they are doing in that employment at the time. Let me give an example. You have a company that has 10 or more employees on January 1st, but they're making toothpicks. They shift into making something that is now considered a hazardous material. And now they've got 8 employees in doing that. I'm just wondering if there should be a nexus between what the number of employees is at the time that the hazardous material is being constructed. Am I going right to the wall here, or?
That is not consistent with how hazardous materials liability is historically applied under CERCLA or under state CERCLA. In those instances, and I can give an example, there was an owner of a parking lot in Pennsylvania, and it turned out that 30 years ago, the parking lot had been the site of a manufacturing operation that had used cadmium. Underneath hazardous materials liability law, the owner of the parking lot was liable for the cleanup of that site. Had nothing to do with the operation of the facility, nothing to do with the use of the cadmium. But it was he was the owner of the parking lot, and under hazardous materials liability and the public policy behind it of having those that were in part responsible for the release be the ones that are liable. That's how the law is structured. It's not about what you were doing. It was about the characterization of your relationship to the property or the release.
Senator Baruth and Senator White.
So I'll just echo something that the chair said, which is if we're going to go back and relitigate the whole discussion about carve-outs, I think we should just open the discussion and move toward Judge Crawford's no carve-outs, because the whole thrust of this bill is to mirror the Crawford decision. And Judge Crawford is pretty clear that he's not carving anyone out. So if we're going to now begin to talk about not just carving out 10 or fewer, but make it 10 employees who are engaged in creating hazardous materials, I feel like we've moved into an entirely new discussion in terms of how we can make it easier to release chemicals and not pay.
But I also want to follow up what I just said to Senator Benning. This is for medical monitoring, and you have to go through the components of the test, and the facility owner is only going to be subject to that cause of action if they were the proximate cause, right? They were the proximate cause of the result. And so it's not that they were a toothpick manufacturer. They were the one that actually exposed the class or the persons to the hazardous material. So there is the direct connection that has to be made in order for this remedy to be awarded.
I'm more inclined to just do away with the defenses than to get into, no, excuse me, do away with the exemptions than to get into, what they were doing and when they were doing it. I had a good friend who bought a dry cleaner and didn't realize that the prior owner had been dumping into the Bennington landfill much of the chemicals from that dry cleaning operation. It bankrupted her, unfortunately. And the federal government didn't really care. They, got their ounce of, got what they needed to make her a partly responsible party, even though she never had anything to do with that. chemical dumping.
So why would you want to move to strike the exemption, Dick? I'm curious.
Why I would want to move if we get to that point where we're exempting who knows what, the toothpick manufacturer who may have, been using some chemical in whitening his toothpicks or her toothpicks. I don't know. I mean, I know it sounds ridiculous, but
No, I think if they were using something that was hazardous, they should be liable.
yeah, well,
And what struck me as going back through this was there was no nexus between the number of individuals in a company that had been exempted and the actual manufacture of the product. I'm floating this out there because I'm really frustrated with how we create legislation in the Zoom environment. I don't feel like and let me back up a half a mile. I'm happy to pass the bill if we plug in the proximate language. I'm just floating this all through my head because we've been wrestling all week with somebody who's been begging us to look at something we did a long time ago and is now claiming there was a manifest injustice. And I don't want to be somewhere 10 years down the road, somebody screaming the same thing about this legislation. I think we need to do due diligence in asking all these questions. I brought it up. I think
Okay.
Michael has answered it as best you can, and you have to make compromises. So that's that.
I would say the defenses are compromises from, the exemptions are compromises from the Crawford tests, and that
I agree.
we're putting in greater protection for Vermont businesses. So with that, I guess,
Well, could I just hear?
Sure.
Mike O'Grady had some language that maybe could make things clearer with regard to the 10.
yes, yeah. What I'm gonna ask is that we give Mike the time he needs to redraft the bill, whether it be till 11 or whatever. We take a break, come back, and I think he knows what you're saying, Alice, and I think we can accommodate your concern by making clear that it's at any one time they had more than 10 employees, not that they had 10 over a 20 or 50-year period. So with that change and then the word proximate, about how much time do you need, Mike?
I've already drafted the proximate exemption or the proximate amendment for the Senator Nika amendment. Do you want the full-time or full-time equivalent?
I think a full-time equivalent is better because it would cover, where they hired. I don't want businesses that avoid paying people benefits by hiring 5 part-time people, which gets me where I want to be.
Okay, so it would
The
say
number of people shouldn't matter whether they're full-time or part-time. It's the number of people that were employed.
So I think it should say where, comma, at any one time, comma, 10 or more full-time or full-time equivalent employees have been employed.
Yep. That sounds good. Do you want a half an hour? That sound good to you, Alice?
Sure. I'll take a half an hour because I'll get it edited as well.
Alice, that sound good to you?
Yes.
Okay, well, why don't we come back here at 10:30? Is that okay with everyone? Is there anyone in the room who can't be back at 10:30?